Okay, so now we are rolling. Hi, everyone. Thank you guys so much for coming. I know it's a Tuesday afternoon. I appreciate your time. It's 3:35, so I figured we get started. I have William Okeeffe and Michael McCann here from Okeeffe and McCann. Also joining us is Javier Rosado, who started their firm as well. Today, I brought them in to talk about new construction. There seems to be a lot of that going on these days and a lot of questions surrounding it. I get questions on it too. Rolling the experts to kind of give us a little more info on it. And then guys, I'll let you guys start.
Thank you so much. So before we, oh shoot, no, I've lost my desktop. Yeah, I'm hoping I'm sharing the screen with the first page of the PowerPoint. Oh, good. So it should be showing just the staff. I just want to orient people. I mean, I'm thrilled that there's so many familiar faces here, and it's kind of nostalgic. We haven't been in person and seen people, whether it's at office meetings or even at closings in so long. So I kind of miss it, but not all of you, Guy, but most of you. We just right now, I just want to introduce ourselves. So it's my name is William Okeeffe. Michael McCann is here as well. You know him well. And newest to the firm is Javier Rosado. He's the latest attorney that's joined us.
Hello, everyone.
For the last few weeks. An excellent real estate attorney and a better cook. So he's a good addition. And just to, from time to time, the staff gets reassigned to accommodate different, practice areas and volume and all. So currently, right now, we have Christine Shirka, who's one of our paralegals, and she's focusing on buyers and lenders. Elisa Schiavo is another paralegal. She's working on sellers. Erin King is a legal assistant who's kind of working on all of the files in the initial stages. So when the files are being circulated for signatures and title orders and survey orders and exchanging the riders, she's on it until it's a completed contract, and it's passed along to one of the two senior paralegals, of course, with the attorneys shadowing it. And then, of course, Heather is still our receptionist. So you can come by and pester her anytime. All right. So as Stephanie said, we were asked to talk a little bit about construction transactions, new construction transactions. I have to say that I was a little self-conscious as I was putting together the slides and the outline, because it ended up being, I have to say, predominantly from the perspective of the purchaser. But it's really applicable to both sides. We're going to be hitting a lot of issues that are peculiar to new construction, because there's a lot of financial timing issues, liability issues that are there's a lot of commonality with an existing transaction, but for new construction, it's a higher degree of sophistication, and you should be aware of it, whether you're on the listing side of it or the buy side. So by no means are we against new construction. I think it's a wonderful transaction. From the consumer's perspective, obviously, everything's new. You have input on selections and customizing, and it's an exciting process. But it is not for everybody. It's a sort of a lengthy process. It could be very stressful for people that are not ready for the commitment or the time element that it takes to get to a closing. So again, I just want to underscore, we're going to be hitting a lot of sort of pitfalls and dangers that you need to be aware of when you're buying new construction. But by all means, on balance, it's a tremendous transaction if you're in the market for one. All right, so financial considerations with new construction. So there are a number of them that are kind of particular for new construction. One obvious one that comes to mind is generally the New York State transfer tax is a seller's expense. It's a statutory seller's expense, and it's measured as $4 for every $1,000 of the contract price. So in new construction, it has become the custom. It's not a law, but it's become customary that the buyer is asked to absorb that cost. I am not certain where that started, but I'm sure it was historical, maybe a generation or so ago, that there was a strength in the new construction market, and the sellers got to name their terms. I would say, as a general comment, a lot of these criteria that we're talking about are a little uncomfortable or sometimes a little unfair, but as a general characterization, I'd have to say new construction contracts are only marginally adaptable. My experience is that generally, if you get a new construction contract with a builder that's doing some degree of regular construction, it's not likely that they're going to dramatically deviate from their standard contract. We do influence it to a degree. We sort of conform it to what's customary, what's fair. But it's, for example, it comes to mind. I'm representing a buyer. This New York State transfer tax is a statutory seller's expense. I don't want my buyer to pay it. I don't even try anymore to try to get that knocked out. It's just not going to happen. It's become so customary that buyers absorb the seller's transfer tax that we leave it as a customary expense. Survey is a little odd. By the way, if at any point anybody has any questions or comment, the default, I guess, is mute yourself so we don't hear background noise. But if you have any question or comment, by all means, unmute yourself and interrupt. If I'm sharing a screen, I won't necessarily see a chat question, so feel free to interrupt. All right, surveys. So this is kind of just a slight detail. Surveys are traditionally a cost of the buyer. What's odd, though, with new construction is that with new construction, it's the seller that arranges the survey, and it's the seller that initially will pay the survey, and we just reimburse them for that expense as a buyer. Normally, the survey is something that our office would order on behalf of a buyer, and the check would be cut at the closing directly to the surveyor. But because in new construction, the surveyor has been sort of working intimately with their surveyor to get the builder their pre-approvals and their site plans and all that, it makes more sense for the builder to arrange the survey and just be reimbursed. Generally speaking, the cost is roughly a wash. It's hovering plus or minus $1,000 for a typical as-built new construction survey. Another financial oddity with new construction is, I know there are a lot of veterans here on this Zoom call. So one of the most agonizing features of our business is the on or about nature of the closings, how frustrating it is, how many times we say it to the client that it's not on this particular date, it's on or about. You have a bracket of time. So in most existing homes, when you're doing the transaction, you have that rough target closing date, and you have a 30-day window within which you have that grace period, right? If you don't make it then the attorneys have the ability to sort of ramp up the pressure by issuing a time is of the essence letter. So you got to wait the 30 days, send the time of essence letter, give 10 days notice to the slow party to cure. And then things can get serious. And things can get,
With the paint.
somebody is not muted here.
Sorry, William, I can't mute anybody.
I don't know if he needs to see like it on this. So.
Okay. So so you have this struggle. You have the ambiguity of the closing date, and then the struggle where you could send the time is up the essence letter, and then maybe you could threaten litigation, but usually we're just bluffing. But for new construction, you usually have a feature in there where if you're untimely, then you have to pay the builder a per diem penalty. And timeliness, in the beginning of the contract, it doesn't feel timely at all. You still have the ambiguous on or about closing date, which we'll talk about in a couple of slides. But when I'm talking about timely here, I'm saying typically the contract for new construction calls for closing within, say, 10 days, some defined days of the delivery to the buyer's side of the certificate of occupancy. Okay, so after that passage of that little 10-day notice period, then the buyer could conceivably be responsible to the seller, to the builder, for a per diem for $100 or $150, however it's measured in the contract, for every day beyond that initial 10-day period. Okay, so that's a peculiarity. You see that also in REO contracts, the post-foreclosure contracts.
Hey,
They're unusual.
One of the ways I try to deal with that is to require the builder to give us 30 days notice before this is triggered. Because it's not fair to the client. They're sitting around waiting, and then all of a sudden they get dropped in their lap. Here's your CO, we need to close. So in order to try to mitigate some of this, I request that the builder provide us with a heads up that they're getting the CO within a period of time so that we can kind of gear up getting the mortgage in place, getting, things finalized on that end.
Right.
So
exactly.
it won't usually do away with it, but sometimes we can get away with getting them to minimize it or give us a little bit more notice.
Yeah, and also one even more subtle tweak that we usually get away with is we change 10 days to 10 business days. So that adds a couple of weekends in there. It almost gives you another, nearly another week. So, and it's kind of incredible. You could be waiting 6 months. I have a closing about to close in about a week or so. We're approaching 2 years, and it was ridiculous. But now we just get the CO yesterday, and now we have to hop to and close in a 10-day period. So it could, that 10 days sounds like plenty of time, but it really passes in a blink of an eye. This is where I get into fights all the time with other attorneys that there's one local project in Goshen that I cringe when I see the file come in, because you negotiate your transaction and then you see the contract come in with terms that were never discussed with the buyer, and it could be off by thousands of dollars. And the way the attorney puts it in their contract is you pay to hook up the water meter, $1,000. You pay to, all these things that are just inherent in the product. It's like, am I going to buy a new car and pay an extra $2,500 for a steering wheel? I mean, it just feels to me to be deceptive. If it's just roll it into the price, charge whatever the price is, but don't charge me a price and then start all these extras that they hide or they try to hide in the contract that aren't customary. And I'm seeing from time to time, they're just pushing the line a little bit and adding these add-ons. I had one a week or so ago where the contract called for the buyer paying $700 of the seller's attorney's legal fee for preparation of the deed. It's just, and of course I sputter, I say no, I say, whatever expletive that I wanted to say. And ultimately we cave, and we did it because it's such a strong seller's market. The buyers got to make the choice. What are your opportunity costs? What other options do you have? And is he going to let the deal, it's nearly a $500,000 new construction deal. Is he going to let it die over a few $100s? He's not. But just when you're dealing with these transactions, you just have to be mindful. Maybe you would be aware of what might be customary for a particular project in Goshen down the road from me here, where they kind of add in a lot of these petty little add-ons that I think all total about $4,000, which I find kind of offensive. But anyway, another issue that we're seeing quite a bit lately is additions in the contracts for unanticipated costs. Now, it's for years I've seen in contracts where the builder will put in some defined sort of ability to increase the costs for, say, excessive blasting. If you have to encounter unusual blasting of stone to clear the site or to dig a foundation, or if you have to do excessive drilling, if it's a well for this property and they have to go beyond a certain depth to get adequate water flow, then you pay a certain cost per foot, or the casing is usually, as a separate item. That kind of stuff makes sense to me. When the deal is struck with the builder, it's struck based on an assumption of what the building cost is going to be, and that's how the builder offers the pricing. What we're seeing, however, is more generic references to these unusual or extraordinary costs increases. Frankly, I'm still trying to digest it and wondering how we navigate it carefully for our clients. Over the last year, the reason we're seeing it is because a lot of the builders are getting clobbered with shortages in supplies, and the prices of lumber and dimensional lumber is just skyrocketing. And and I get that, and equitably, I think the parties should bear that. It shouldn't just be borne by the builder. But from our perspective, when you're defining a contract, I want to grasp at something that will give you some ability to objectively define whether or not we're being charged appropriately. So if you have a clause that says something like, the seller reserves the rights to charge the buyer if there are any unanticipated extraordinary costs of building materials or something like that. Assume worst case scenario, which is what the attorneys have to assume pretty much all the time. We're in court. How do you define what's extraordinary? How do you define what the baseline costs would have been? And is this uptick of $10,000 now that suddenly the builder is asking for, is it appropriate or not? So we're kind of struggling with ways to define it. Usually, I think Michael and I were talking about this earlier in the week, and he had one recently where it has that kind of broad clause, but it also says if the buyer doesn't agree to this bump of whatever it is, whatever the builder is asking for, then the buyer does reserve the right to cancel. So it's not completely unilateral that the builder can ask for whatever they want to, and the buyer is stuck. It would put them kind of back into a negotiating posture. Still not a perfect situation, still downsides and dangers with it, really, for both sides. This one that took literally nearly 2 years, that's about to close. I understand that the builder is probably suffering a loss. He's not going to make any profit in this transaction because he didn't have that kind of a clause in the contract. But I would argue that it's a motivation to get off your butt and build your damn house and build it timely. If you're promising a house in 3 months, you're not as exposed to the fluctuations in the cost of materials market as much as if you're going to take a year and a half to build a house. So we're kind of wrestling with that one as well.
I've also tried to limit it as a percentage of the sale price
Yeah.
to any increase to make it 1% or less, something along those lines. Not that it helps, but
Yeah, it's just what strikes me, it's just difficult to measure and to really assess whether it's in this particular case when we get a closing statement and it's got the little uptick for whatever it is. If it was blasting costs or excessive drilling, I could say, okay, give me your invoices for the extra drilling, and they certify the depth of the well, and if it goes beyond it, I have an objective measure. If blasting was required, we would have heard it when the client was stalking the property every weekend. You know, here though, it just I don't know. I think it's ambiguous, and it's going to be rife for a lot of conflict at the closings. But all right, the other thing, another financial consequence or feature of new construction is you have a little bit of a consideration of exposure for rollback taxes. Rollback taxes, if you're not familiar with it, is basically if this parcel is benefiting from some enhanced type of tax abatement. Usually it's in the context of agricultural exemptions or something. So you have a bunch of acreage and you're not really farming it, but you rent out the part of the property to hay it or something. You qualify somehow for this agricultural exemption. And then the property is subdivided and sold to your client. The municipalities have the ability to grab back not just this current year, but back, I don't know how long it goes back. Maybe someone here knows, a year or
5
two.
years.
Is it 5 years?
Yes.
I didn't know it went that back. But anyway, they can go back and undo the benefit of the exemption if you lose that status. So it's prudent for us in the contract stage to add a clause that has the seller indemnify us or indemnify the buyer for any rollback taxes that come on the rolls after the closing. Okay, I've had
the last one I had was about $2,000 in tax differential, and they gave it to us as a credit at closing, so that when the tax bill comes out a year or two from now and it's on there, my clients are just going to pay it.
Yeah, and that's the cleanest way to do it, because honestly, once the closing happens and it's 6 months or a year later and they're feeling this pain, it's difficult to get back in the room with the seller and try to get these credits back. So you can kind of extrapolate and anticipate what the loss is going to amount to. You know, if it's a subdivision that was created a number of years ago, then your exposure is very limited. The rollback burden would have happened already. But if it's a fairly fresh subdivision, then it is cause for exploring a little bit. Okay, escrows and upgrades. So for these, you guys all know that the default for pretty much any existing home, any transaction, is that the down payment that's put down on contract is held almost always by the seller's attorney's in the seller's attorney's attorney trust account. All right, and that's usually the case with new construction as well. It's almost always still held in trust, the down payment. However, what the slide here is trying to underscore is the exposure for those funds that are advanced to the builder himself for any extras or upgrades along the way. Sometimes it's at contract, sometimes it's as the decisions were made to do an upgrade, sometimes it's as the upgrade is installed. And you can have a contract that says, there is no there's no further advances. The builder is going to cover the costs along the way, and they're just going to get paid for those upgrades at closing. You can have some where the extras have to be paid in full as the work is being done, or as the choices are made to do it. And basically the builder is using those advanced funds along the way to do the work, right? So you're helping kind of to finance that extra work. There's some contracts where maybe half of the upgrade cost is paid along the way. So whenever any funds are put into a down payment account, into an attorney trust account, we can get them back. We know they're secure, subject to an attorney's license. We know they're not going to screw around with it. So if we had to litigate, we would know the funds are there. If it's released to the builder, it's much, much more complicated. So imagine a case where there's a default by the seller. We just, I don't know, 2-3 years ago, there was a builder who was starting to put, and this in new construction loans, where there are different thresholds of work and different advances by a local bank. And the money that was advanced from this bank was used on another property, and all kinds of shady stuff was being done. And ultimately the builder filed for bankruptcy. There was also criminal, I don't know what happened with it, but I think pretty significant criminal consequences. And but the people that were involved in it, when the seller files for bankruptcy, what are you going to do? Where are you going to get that money back from that was advanced to the builder? It's not in an escrow account. I can get a down payment back if someone files for bankruptcy, because that's not part of the bankrupt estate. But if it was released to the builder and now intimate and part of the home, it's very difficult. So again, this is one where it's this terrible discomfort as the buyer's attorney. But it's almost like you got to have the conversation with the client, advise them of the risk, and pretty much let it be, because it's very rare that you're going to get a builder that's going to change their new construction contract or practice and not and have it just posted as further escrow or just paid at the closing. Another little workaround you can sometimes do is decide on all your upgrades in the beginning. Make your decision before you start breaking ground and roll it into the price. Just have it as the full price, and then there's a little less housekeeping that has to be done along the way. Also, even without the kind of strange circumstance where there's a bankruptcy or a breach of contract by the seller, you can have a situation where the buyer has a right to cancel. And you have the right to say the appraisal comes in short, and you've put in a down payment of 50 grand, and you've released 20 grand to the builder to do some upgrade, and then the appraisal comes back and it's short, and you can't come to terms on a renegotiated price. You cancel. It's easy to get the down payment back, but it's not so easy. It's not liquid to get the advances from the that were, literally it's timber in the house. It's lumber. So it just complicates it. It's a risk. It's, unfortunately, it's mostly going to be an inherent risk that we're going to have to either not do new construction or just accept it and take that risk. Just on the on the escrows and upgrades, I would say the majority of new construction contracts probably have a clause that says that the appraisal that's part of the mortgage contingency, it only needs to appraise at the base price, not the extras. Okay, so that's just another fact that that you got to make sure the client is aware of.
And just in regards to extras and upgrades, they all be done in writing. It sounds self-obvious, but I have a deal right now where the builder and my client made all of these side deals, and everything is going to hell in a handbasket on it because they're fighting over who owes who what, who owes who credits, what work remains to be done. So if it's in writing, they can't dispute it.
Yeah. Yeah. All right. So as to timing, again, it's agonizing with an existing house. The anticipation of a closing date is really hard, and I don't know why New York State is so difficult to do it, where other states, you shake hands and decide that you're going to close in 4 weeks, and you actually close in 4 weeks. And here we're waiting for municipal reports, sometimes a month plus later, and we're just at the mercy of the building department. But that is the nature of our business. So as difficult as an existing home is to predict a closing date, new construction is more so, because think of all the variables that have to be buttoned up to get to the closing table. First of all, they're juggling usually multiple projects at the same time. And sometimes they're coordinating tradespeople. They're not going to have a guy come and pour the concrete foundation or for the sidewalk or something on just this house and then come back next week. They're going to coordinate it so the truck comes, and they do the projects back to back. So there's a lot of, hurrying and waiting and tying the projects together. There's weather that can kill you for a month or two, muddy or snowy weather. Supplies were a big issue this past year, and building departments, frankly, they've been overwhelmed, and it's just, they're overwhelmed with volume over this past year, and they're terribly understaffed. So there's just, we just have to be patient and understand timing is an issue. That said, usually the contract will have some kind of clause in it that will have an out. If the house, if they're promising the house in 4 or 5, 6 months, and you can have a clause in there fairly easily that says, well, if the house isn't delivered in 8 months, 9 months, a year, whatever it is, you would have the unilateral right to cancel. Okay, and sometimes the seller has that right too if there's something that's beyond their control. So it just gives you some degree of confidence that it's not going to go on forever. This is just it may seem like a minor point, but when you're a buyer and you're in breach of contract, what happens? How does the seller make it painful for you? Where's the leverage that the seller has over the buyer? Mary Ann.
I'm mumbling and I'm saying to myself, could it be the contract money? Because that can't.
The down payment.
Yeah, okay.
Right. The buyer risks the down payment. So now go the other way. What if the buyer is compliant and the seller is breaching? What do? You don't have their money. You don't have their down payment. They haven't posted any good faith money with anybody just in case they screw up.
You sue.
You sue, and the teeth of the suit. First of all, the suit initially is it sounds all well and good, but it's very costly. It's expensive. It takes forever. It could take a couple of years to litigate a contract case. But the teeth to it is when you start that suit, you can also file what's called a lis pendens or notice of pendency, right? And that is like this blockbuster, the equivalent of a lien against the house, warning the rest of the world that this real property is the subject of litigation. So it chases off any future other buyers from coming in and being interested because they're not going to get insurance until this litigation is resolved. So that's our leverage to it, right? So the reason I bring that up, and that's what makes the buyer and seller transaction fairly parallel. The risks, both sides have pretty good leverage. But in new construction, any attorney is going to counsel the builder to have some liability protection. So they're going to have liability insurance, of course, but they're also going to incorporate in some form. They're either going to be a corporation or there'll be an LLC if it's like a investor type person. But in any case, there'll be some corporate protection so that the liability of that entity won't go beyond the entity to the personal, the real, the person that's the builder himself, right? So what we see sometimes are these very clever little schemes where a builder has they want to go into a contract to build and sell this house to the buyer. But if you ask and you probe, today, that builder doesn't own the property. Okay, in many cases. They have a related but different corporate entity, like an LLC, that owns the property. They're the member of the LLC. And why do they do that? They want to cut the legs out from under me as the buyer's attorney, because I can't file a lis pendens against someone who's not a party to the contract, right? So if, yes, Marianne.
Well, then I'm wondering, on that note, couldn't you then insist in the contract, instead of an LLC name, that you put the buyer's name with it?
Well, I have this clause.
With it, the seller's name with it?
Yeah. I do something like it. It's there's a clause in there that says if the seller on the contract, as it came to us, isn't the present titled owner, then the titled owner must also be a signatory for all purpose of this contract, except post-closing warranty issues, and that's just the builder themselves. But that ties them in, and that gives them, some incentive that, to abide by the terms of the contract, because they're vulnerable to me, putting this, car boot on their car that they can't drive away with my house if there's a dispute, right? So, because if they have that corporate structure, I could sue the corporation that's a builder that's in default, but but they're technically, it's a different entity than the landowner. So I need that kind of leverage back, so we don't get bullied. All right. How many people do bring an inspector after new construction and before the closing? I think it's a minority of people, but I think it's a great idea because I wouldn't know. I mean, I'm pretty handy in my house, but my God, there's all kinds of stuff that would pass the building department's inspections for a CO, and that's big stuff. But there's a ton of stuff that you might not catch. So I would really, I think you guys should have at least 2 walkthroughs for new construction. Do one a little bit upstream, 2-3 weeks in advance of the CO being issued, and get an idea of what's going on. Maybe have the home inspector there to say, listen, this is not at capacity. This is, I don't know how this slipped by the building department. But you could start a punch list, and then just hopefully most of the stuff will be finished by the time the closing happens. Or you might just have some nominal cosmetic stuff left over, but at least you can get the work started prior to the closing. And the same thing for radon. Radon is not something that happens to a house just because of age. Radon, a house is vulnerable to radon because of its geography, where it happens to be and what's going on in the soil below. So, you might argue that a new construction doesn't have cracks in it, so you might not have the radioactive gases coming in as much, but still there's a vulnerability, and you might as well get it tested, because at new construction it's super easy to install the little PVC stub, so that all you have to do is add the fan to vent it out. It's it's better to get that information up front. Although, I put a note here that to be wary of radon tests, maybe having a false pass or a false fail. That the testing standards are on the assumption that it's a normally occupied house. So, you know, if you've had a house that's kind of unoccupied for a couple of months, there's a decent chance that it's going to fail sort of unnaturally, and it's a false fail. But the opposite can be true as well. If you're doing a radon test in a house that's over ventilated because the doors are constantly open, the windows aren't installed yet or something, then you're not going to get a true read on that either. So you're going to have to do it in conditions that are closer to normal living conditions. Again, the punch list, you know, it's helpful to have the inspector's input. You know, if you don't have the inspector, you don't want just the party out there to fend for themselves. You want you guys as an objective professional to be there to help build this punch list together. Usually, I would say in most cases, I'm assuming, the builder or the builder's representative is there as well. So you kind of hash it out and you figure out what's got to be done, and you put it in writing. As Mike said, it's got to be in writing. Otherwise, it's you know, you're just inviting a problem. Just note that in most new construction contracts, there's a clause that says that the builder will not hold escrow for post-closing punch list items. You know, and that's one that we could rarely get by with. The argument is, if they've gotten the CO issued by the building department, then the house has got to be in pretty good shape. But you know, still, there could be some pretty significant items that are not adequate. But since we rarely are successful in holding an escrow in new construction, the better course, the prudent thing, is to get these items addressed in advance, and hopefully it's taken care of prior to the closing, so we don't have that issue of exposure.
I, for the first time in 20-something years, am doing a site visit tomorrow with my client, the builder, the realtor, the other attorney, because no one can agree on what the punch list items are.
Oh, is this the one? These are the people that you met with for like
Yes.
6 hours yesterday?
Yes.
Yeah. Oh,
So
that's good.
there's a certain level of managing expectations too on what
Yes.
reasonable building standards are with
Yeah.
people. So it's just, I don't know where this is all going to end up. I hope well, but there's really no way to resolve that. If they can't agree, we're kind of in a standoff as to, he says the house is done, he got the CO, even though there's no cabinets and no floors, which I'm not sure how that happened. But
Yeah, I
now
think
we
that's
have to
good.
close within 15 days or pay penalties. So
I think it's great to have them all in the same room. We get super courageous when we're at our keyboard and on the phone, but when they're all in the same room, hopefully that'll.
Right, all right, okay. Sorry, I'm in a meeting for work, so I'm like.
Okay, and then for any punch list or post-closing items, as best you can, set deadlines. You know, sometimes they're weather dependent. Seeding is notorious. You know, you'll have a closing in the colder months, and you just have to wait. There's no way around it. But you know, you could set a date. You could set a when weather permits, and but as best you can, set some expectation as to when this work is going to be done. Warranty issue. Oh yeah, Mary Ann. God, you're a pest.
Well, I'm answering your questions when you called on me. I'm wondering, you do the same things for grass. In other words, you said winter and you put it in writing. Is that sufficient? So like you close in the winter and there's no grass, do you put specifically in that they're going to seed, how far back they're going to, sidelines?
Yeah, that's one of the ones. It's kind of a pain in the butt when we're doing these contract reviews, because you have a variety of quality of builders, and some of them are wonderful. Any disturbed area in the lot will be finished graded, and what's the power raked and hydro seeded or whatever it is. and some of them are like, I'm going to do 10 feet in the front yard and 12 feet in the backyard, and that's it. And it's just, you got to be careful, whatever is included or not included. Again, if it's a wintertime CO and closing, there's really no way around it. We've got to wait for the weather to change in the spring, and you just have to enforce what the contract was, what the specs called for. And again, it could be nothing, or it could be as fancy as you roll out the sodded grass, which is.
And the reality is the punch list and the warranty are only as good as the builder.
Yeah.
So if the builder is not a good builder, they're not going to come back and fix the punch list items. So getting it done with specificity in that punch list, it may come to you have to pay someone else to do that work and then sue the builder under the punch list to get the cost back.
And unfortunately, that's a pretty distasteful option because of the cost and the time and all that. So a lot of times what you have to leverage in our industry is their reputation. I work for the largest real estate brokerage in New York. And is this the reputation you want my office mates to be learning of your work? And hopefully that would be chilling for them, that they would kind of step up and do the right thing, because that's good for their next transaction. So just a couple of comments quickly on warranties. It's not something you can contract away, like the New York State transfer tax, where by contract, they can make the buyer pay it. Here, you can't waive the basic warranties. So the New York State General Business Law has the basic warranties in it, and the builders can't do less. They can have their own, and it can have some peculiarities and all to it, but you can't have a contract clause that says, oh, there's no warranties, okay? So sometimes the contract comes with no mention of warranties, and then it defaults to the New York State General Business Law. Sometimes the contract will attach that builder's warranties. Sometimes they contract with a third party to service their warranties. Okay, so you sometimes see some money passed, similar to an existing house where you buy the $500 or $600 warranty policy for the first year. The builder can pay a couple $1,000s for a home warranty, and the builder can walk away knowing that this warranty company will stand behind it. We sometimes see a warranty liability cap in the contract, where the cap of the liability that the builder is exposed to is limited to $50,000 or something. I usually try to push that up higher to $100,000 or so, because if there's, God forbid, some sort of major structural problem, you can blow through the $50,000 threshold pretty quickly. So, we're not going to get into the details of what a warranty is and what they are, but just be aware that there are different thresholds, different timeframes. The more kind of smaller cosmetic-y things are in a shorter time frame, of maybe a year. The more structural major systems are longer. The appliances, the stuff that are installed by the builder, are not generally part of the builder's warranty. They have their own appliance warranties. The builder would only be liable for those kinds of warranty claims to the extent that the damage or defect is caused by the installation of it. Okay, but other than that, they're not obligated to replace the computer in the dishwasher. That's a failure of the dishwasher manufacturer that you pursue.
And just a note on the warranty: if the builder goes belly up, the warranty goes away. So if the builder is the one that's giving the warranty and they fold tents and close their corporation or file bankruptcy, there is no warranty.
Yeah, a lot of times you have a right, a contract right, but no practical remedy to collect, so. it gets kind of grim doing these contracts because we have to anticipate really worst case scenarios, most of which never happen. And then we add this little peculiar clause in our rider to say, okay, we're covered. We're going to cover that. And that thing then never happens again in our career. And then something else comes back and stings us in the butt. And we're like, oh, we have to put that in our rider. And we put that in the rider, and then that'll never happen again. So it's a lot of grim anticipation of all these stupid contingencies. But all right, this slide I think Michael kind of touched on earlier. You know, don't wait. We know that the timing usually requires us to close within 10 days of delivery to us of the CO. So you're not going to sit on your hands and wait for the CO before you start buttoning up your financing. You're going to have communicated with your lender. They've done the preliminary appraisal. Maybe it's just subject to a quick inspection after, you know, everything is complete. You know, again, you know, maybe multiple walkthroughs would be appropriate. Again, as Michael had said, put it in writing. And what we're talking about is the statute of frauds. You remember back from your licensing class days, Hillary, that the statute of frauds says that any contract for the purchase and sale of real estate, or any contract that calls for performance over a year or more, has to be put in writing. You can't have an oral agreement that's enforceable. Okay, it's a void contract if you try to do it that way. So you got to put these specs and any change orders in writing for them to be sort of folded in to the contract itself and be enforceable and satisfy the statute of frauds. Because otherwise, as Mike was alluding to before, if you don't put it in writing, you know, you can have people acting in good faith that their memory fades and the costs go up. So now they're feeling resentful of the buyer because they're getting a deal relative to the cost. And now they want me to put a, you know, a 5x4 concrete pad in the back of the house where they want to put a generator, and they want to charge for it. You know, so whether there's going to be a charge for the concrete pad, or if they're going to be comped on it, where the location is for that concrete pad, whether it includes the little sub panel box, the electrical thingy that you got to install. I had to deal with those very things, that it was kind of a handshake agreement. It wasn't put in the right place where my client wanted it. The builder wanted to charge the, whatever it was, $700 for the little sub panel. All that kind of stuff, you know, avoid the conflict by putting as much detail in writing as you can, because memories fade, and sometimes people do try to pull a fast one on you on purpose. Sometimes we get lazy and we might say, hey, I just want to include, you know, we're emailing the other attorney. We want to confirm that the seeding of the grass is included in the specs. It wasn't mentioned, we needed, you know, and they say, yes, it is. You know, there are some contracts where it actually says that the attorney can bind the seller or the buyer as the agent of them. Usually, though, that's not the case, and we would have to go the next step and have the builder initial or sign off on that, almost like a change order, just to make sure it's legally enforceable if we went to court. I feel like, you know, Michael and I are venting, because, you know, all these things where he's chiming in about putting it in writing and warranties and all these things we're talking about, they're deals there that we or our clients kind of got burned on, and you know, we just it's not fun to go through it. Some of them are significant issues, you know, thousands and thousands, sometimes many thousands of dollars at issue, and a lot of high emotions involved, and So the more we can address these issues kind of upfront, by far the better. So anyway, those are our 2 cents on sort of the peculiarities of new construction. Are there any questions for any of us?
I did see a question in the chat. Leanne asked how much of these details should be put in the purchase offer.
Yeah, I mean, practically speaking, from today, probably not a lot. I think, you know, this is kind of more sophisticated stuff that is, you know, a lot of it is fleshed out by default in the contracts. And if you, hopefully you know, the attorney is familiar with real estate and does a fair amount of new construction, so they know the pitfalls and they know what to add to their riders to address it. I think you know, in fact, from your perspective, I would argue that you probably would be exceeding your license if you started, you know, adding too many of these fancy contract clauses, because you're not, you know, you're not supposed to be practicing law. And, you know, I would just, you know, you should be aware of all these issues well enough to know, you know, when the hair should stand up in the back of your neck, that, okay, this is, you know, I got to remind my client about this, or you tell them to talk to the attorney about this, make sure that's put in the contract. But I don't think it would rise to the level of you guys having to have this, you know, you have your 1-page binder, even with new construction. You know, you're not going to start doing a rider to the binder that you're going to have your 3 pages of cautions and all this stuff. So I say you leave it to us for that. But, you know, again, by all means, have these conversations and make sure that they talk to their attorney about it to make sure they're protected in the contract itself.
I really think it's more relevant to, do you want to buy new construction versus do you want to look for a house that's an existing home? And that's a conversation that you should have with your potential buyer.
Yeah.
But, you know, in the context of knowing what these type of issues are, because these are all completely different and unique to new construction versus buying a foreclosure, which has its own special issues, or buying an existing home, which is the standard routine deal. So
yeah, it really, new construction is, it's exciting. It's great to have everything new. Every appliance is brand new. You're picking your cabinets, you're picking your flooring, you're picking your colors. It's great. But it's a grueling, you know, every once in a while we have, you know, you guys too, you have a deal where it's new construction, but it was a spec house and it's almost done. All they got to do is put in the flooring or something. It's like the Goldilocks deal. Everything is new, but you don't go through the sort of the agony of biting your fingernails and arguing and all. Or waiting you know, indefinitely. It's like the buyers have a part-time job for the next 6 months while they're kind of wrangling the deal.
So really, I always stress the importance of like using local attorneys, because there are so many things that go on in like Orange County and Rockland County and just in our little hub that are different. But especially when dealing with new construction, I would definitely get an attorney, guys, that is well versed on it. You know what I mean? That knows a lot about it, fully knowledgeable, just like Okeeffe and McCann, because it seems like it really does make a big difference.
Well, I mean, when you say local, I assume you mean Goshen and St. John Street in Goshen specifically. So
exactly, yeah. No, seriously.
Yeah, thank you, Stephanie.
I'll stress that. Does anyone have any questions? I mean, I thought the presentation was excellent. I know a lot more about new construction and I don't need half of that, but it was very, very informative. Anyone have any comments? Any rave reviews?
Well, thank you.
That was great.
I assume that's for Okeeffe, Diane.
Wait, what was that?
What?
I missed it. Was there
Nothing.
was there a gesture of some sort?
Never.
And it wasn't a thumb up?
No, this was very good. And for those of.
I think there was a finger involved, but I'm not sure which one it was.
It wasn't that one. It was.
I'm going to stop recording.